What's going on, everybody? I wanted to do a quick little tutorial about court. I've told people this numerous amounts of time, so I wanted to go over this. Actually, the brother in this case represents himself well. There's just elements that he doesn't know that I want you guys to kind of pick up on. If you understand how court goes, once you challenge jurisdiction, if you allow the court to to move forward, it's going to usually be at your peril or at your detriment. And there's a reason why the judge plays this type of game. Okay, the judge is he's in the mood of playing like he's playing with house money, and he is depending on who's his opposition. When his opposition knows a little bit more than him, the judge will dance a little bit more. They'll what he's trying to probably do in this is, and I'll tell you it in the video. So I'll let you get into it and kind of let it go. Oops. Wrong way.
Another judge runs from the Sixth Amendment.
And it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules, is that statutory law?
I'm not going to keep going back and forth with you, sir. All I'm going to do, lastly.
It doesn't matter if it's statutory law, etc. What it does matter is if he's challenging the court or the authority of the judge. That's all that matters. It doesn't matter if it's statutory or whatever. Now, we know statutes aren't law. They could be derived from law or derived from acts. And we know statutes aren't law, but it doesn't really matter. A lot of times people get that script and they go into court and they keep using the same script. But the brother's very knowledgeable. He knows he knows what he's saying. He just doesn't fully know the process. And I'm not saying he can't get wins or whatever. I'm not saying that. When I'm saying that, I'm never disrespecting somebody, because I appreciate anybody that goes into court and stands up. We have enough cowards in this country. I appreciate the people who aren't.
I'm not going to. She has a valid driver's license, counsel. All I'm going to do, lastly, is give you the dates that we have.
Your Honor, there is no international contract. We've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding. And I'm not aware of any contract. In the absence of such contract, I motion that we dismiss this case.
Bing, 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 bing. So where I think I did another video, and then I think it was either Right to Trial or no, the video where I was talking about that script. People go to court and they try to use the script saying, the court has two jurisdictions, one of the admiralty and the common law, which is not correct, but people still use it. You see what I'm saying? So they use the script and then they don't understand what to do in court. So when he brought it up eloquently and moved to dismiss. Okay, so when you move to dismiss the case, all you need to be doing is looking at what the judge says. Okay, watch what the judge says. If you ever say, I want to file a motion to dismiss, and the judge drags his feet or does you dirty, you need to instantly ask him to recuse himself, because he is biased. But that is a trick that judges will do just to get the case up off of them. He should not, if you're ever addressing a jurisdictional question, you should not be speaking to the judge. The judge is not there to prove jurisdiction. That is not his job. Okay, so y'all need to know that. So that's his problem. He's arguing with the judge, and the judge knows that he doesn't know this. But he's handling himself well, and I like it.
I've already
Yes.
dismissed that motion.
Yeah.
You can move to.
Dismissed it based on what? That's what I would have asked. I would have asked the judge. I would have said, I need you to file either a brief or written order that shows why you dismissed the order, so I can see what legal conclusion I have. Otherwise, I'm going to take it as a violation of my rights, because you're dismissing an order, but you're not telling me why the order is dismissed. You're not giving a legal basis for the dismissal. You're just sitting here stubborn and just you just move your lips, but nothing comes out. He moved lips. I think you forgot how to act in court. All right, instead of forget
The
about
circuit court, and you can appeal my decision as it relates to that. File a motion.
See, the judge is telling them what to do. So you always listen to what he or she is telling you what to do. If you know how to actively listen, a judge 90, I would say any 90% of time will show you how to beat your case. If you listen to the judge, they will tell you how to beat your case. You have to decide, you have to be able to decipher through bullshit. Like you have to be able to listen and hear. They will. I'm telling y'all, it's just a lot of times people don't know how to actively listen. So then you get frustrated. Most people would have been in this situation. They'd have got frustrated. The judge would have had them rattling. They would have started raising their voice. And he's calm. He's cool as a cucumber because he understands. Like even if the judge abridged my rights, I still have recourse.
I'm going to give you a date. I'm going to give you a date where that motion is going to have to be due. I will entertain that. I'll give the.
If I'm filing a motion to dismiss and you don't grant it, we're not going forward in court. You will not see me in court no more. Because by that time, the court case is already done. You see what I'm saying? I'd already wrapped it up. So I wouldn't have been in here. If I filed a motion to dismiss, I wouldn't even be in here. It doesn't make any sense. You guys challenge jurisdiction and then go into court. That's why the court keeps stringing the case along. You can't challenge jurisdiction and keep going and let the court case go.
People a date on their.
This is obvious collusion. Because see how he's arguing with the judge? He's not supposed to be arguing with the judge. The judge is not even supposed to be doing this. The judge can't prove jurisdiction.
Response if they choose to respond.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time. And there's been no evidence of any jurisdiction, and I don't understand why, you're insisting on, moving to another court date, and we have not addressed.
Because you're challenging the court's jurisdiction and you're not challenging what the court is doing to prosecute you. That's why. See, that's why people have to understand that there are nuances of law that you have to learn. He is challenging the jurisdiction of the court, but he is not challenging what they're doing. He's not challenging the process that they took to get them there. You see what I'm saying? So when a judge does something like this, you have to kind of you have to keep it in mind that you're challenging the jurisdiction, but it's kind of how you present the jurisdiction. But I'll let him go on because he's doing well.
Fundamental issue of jurisdiction. I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest.
Under what grounds? Under what basis are you putting a warrant out for my arrest? And you
I didn't say I was going to put a warrant. I said if you're telling the court that you're not going to come back to any court dates, then that's up to you.
He didn't say that. He did not say that. See, that's what the judge is hoping. The judge is hoping to issue a warrant because the average person does not know how to get rid of a warrant. So the judge is hoping that he not blow trial, but allow them to move forward, and then so the judge could put a warrant on the docket.
I don't wish to.
But here's the issue. They're both right. The judge is right and he's right. You see what I'm saying? But there's nuances where he's wrong because what he's bringing in court, he's not bringing it fully correct and following the rules of court. And that's what the judge is letting him know. Like, hey, we still have.
There's been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit.
Well, here's the issue with that. The international contract is the proof of debt. Okay. Sometimes people, we regurgitate, or a lot of times people will state stuff. The international contract is the evidence of indebtedness. That's why I did a video talking about 27.11 CFR. Under definitions, it tells you offenses of the revenue, because if you go into that statute, um, it'll basically tell you they'll talk about the commercial crimes. Well, that's where everybody's like, oh, crimes are commercial. And I'm like, well, no, a lot of crimes or a lot of violations are offenses of the revenue. So what happens is, once a traffic ticket is drawn up, someone has to settle it. I hope that makes it clear for a lot of people who, comment and stuff and may not know how this goes. Yeah.
And the prosecutor can't provide that. And it seems like there's a bias going on here, because flat on his face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date. And I don't understand. I mean, your oath of office is to uphold the Constitution.
What you're saying in essence, right? What you're saying in essence is that I don't have any authority.
I'm asking you to prove your authority.
Huh? I'm not
asking you.
It's not, here's the issue. It's not the judge's job to prove his authority. How can that judge prove their authority? They have no authority. It's how the person phrased the question. He phrased the question incorrectly. He's supposed to state that this court has no jurisdiction. Okay? Not that the judge is not who you're attacking. The judge is not your enemy. The judge is just there. Okay? Obviously, this judge is being more biased to the prosecutor because the prosecutor knows the rules. It's not always that you're pro se. Okay? A lot of people come in and they start quoting this stuff and they're like, okay, there's a lot of nuances about it. So that's why I do some of these videos where a lot of times people have the remedy. It's just about they don't have the understanding. Once you have the understanding, you'll get the remedy every time in court. I'm just telling you this because you'll know what to do if they railroad you or if they do you wrong.
Prove your authority. I'm trying to understand where your authority is coming from. And you're failing.
Read the Michigan court rules. Read your statutes. Read the Constitution over again, and you'll find that.
But see, here's the issue. The issue is not the judge's authority, or it is the judge's authority if he ruled. Okay, if he doesn't rule, then you can question his authority, and you can stop the case. And there's ways to do that. But his questioning is asking, where's the authority? The question is basically what standing does the state have? You see what I'm saying? So for the judge, you can let the judge know in these situations where the judge is trying to help the state, let them know that the state doesn't have any standing. And the reason why the state doesn't have standing is basically, how can the state, you're supposed to have the ability to be in a fair and unbiased tribunal. And if you're in a tribunal to where one side has plenary power, and you come in there and they're basically making up rules as they go, using the evidence of indebtedness against you, because that's why you lose in court, is the evidence of indebtedness. If they're going to use the evidence of indebtedness against you, then it's going to be something to where it is a revenue issue. Okay, because the court has to make its money too. And that's what a lot of people don't understand. That's why I try to explain to you, there's a difference between the traffic stop and the court process. These are two separate events. So to get rid of a case, you need to either specify either both of these events or one of these events. And that's where people mess up. That's why I do these right to travel calls and all that stuff. It's not to say, you don't have the right to travel. That's solidified in law. There's no need to argue that. It's not to say that somebody, process doesn't work or anything. I'm not arguing that. I'm just bringing it to a clear, and concise conclusion, or not a clear, concise conclusion, but I'm trying to show people basically somehow how they may have issues when they bring up a right to travel claim. That's basically it. I'm not showing anything anybody Don't know.
As I said before, I'm not asking you for legal advice or where
And
to
the
go.
Michigan Constitution.
You have, if you have a legitimate jurisdiction, I'm asking you, is it a criminal jurisdiction under statutory law, or is it under the common law?
All right, we're gonna give him a trial.
And you will not answer that question.
Well, we'll give him a jury trial date.
But he's not bringing it up properly. You see what I'm saying? He's not bringing the question up properly. That's not a question for this court to answer. You see what I'm saying? This court can't answer that. They can't answer. That's like going into like McDonald's and asking McDonald's, where'd you get your authority from? You see what I'm saying? McDonald's is like, well, we got our authority from the charter and we set it up like this and we set it up like that, blah, blah, blah. But I'm like, that still doesn't give you where you derive your authority from. So that's why I did the video and I said I wasn't going at any other channel or anything. I wanted to show you guys that how a lot of times people might make statements they don't understand. If he's challenging a jurisdiction, there's really nothing else that we need to talk about. We don't need to talk about his authority, nothing. We just need to talk about the event that took place and why the court doesn't have jurisdiction over that event. And a lot of times that's where people make a mistake. They'll sit there and start making vague claims or they'll ask questions. But if you're asking this question, the moment you ask the court or the moment that you state that the court lacks subject matter jurisdiction or any jurisdiction, whether it's personal, personam jurisdiction, etc., you have to be able to know what happens next after you do that.
Wow.
August 9th, 2022.
Your Honor, we cannot proceed until I understand the nature and cause of the action against me.
I'm gonna say this one last time to you, sir. Go, and if you want to speak to the court, if you have any objection to the court and these dates, and if you don't feel that these dates are lawful, and if you, whatever your claim is that you're stating, you speak to the court through motions. I want that, and those motions that you're entertaining on the record right now, I've dismissed some of them already. I want you to file those motions with the court.
Under no basis ground.
So the question he should have asked himself is, how is this judge? Why would I say that this court lacks subject matter jurisdiction or lacks jurisdiction, and then give the judge an order to rule on? You see what I'm saying? So if you're going to say that the court doesn't have jurisdiction, you need to move the case. You need to object to the venue. You need to object to certain elements of the case. Because if you let him go on, you've already filed motions in the court. So he's like, well, I can set a new court date because you petitioned the court and you allow me to rule on it. So while I said that a motion does not grant jurisdiction, a motion does serve as evidence that you're either trying to move the court forward or stop it.
So that the court can read your motion and make a ruling and give the city attorney an opportunity to respond. If you do it the proper way, you might learn something, even if they show you documentation like it is in black and white. You're not going to believe that anyway.
I still have this same question that you keep failing to answer, and without that question being understood,
and that's it. I'm done talking about it. Okay, that's it. So I'm going to set a
let the record show that the judge has refused.
Listen, sir, don't interrupt me again. Okay? Don't interrupt me again. Let's set a motion date for.
I do not consent.
Please don't. One.
So now what he did is he put the judge in a rock and a hard place. And I know some people say he's standing up for his rights. He's standing up on his square. And, if this is all you know, this is what you know. You see what I'm saying? So I have to respect people's knowledge because people have different levels of knowledge. So I have to respect it all. And with him going into court, and he's going and kind of he's what is belligerent claimant. The judge is going to stay in his ground because obviously nobody wants to, secede. And that's why a lot of times you see these so-called sovereign citizen titles, but really is somebody trying to stand up for their rights, and they may not fully know how to do it. But yeah, he's doing the best he can with the information he has.
Do not say anything else, sir. I know you said.
Sir, I'm exercising my Sixth Amendment right. The Sixth Amendment, exercise of an amendment right cannot be converted into a crime, sir.
I'm holding you in contempt of court, sir.
As I stated before, I'm trying to understand the jurisdiction of the
I'm not
court
going to deal with you. You're going to jail.
pursuant to
I'm holding your client. Well, Mr. Berry, you are, I guess, not representing this client because this client is probably. Do you want the representation of a lawyer, sir, at this point now, sir? Because now you're looking at 30 days in the Wayne County Jail. Do you want the representation?
Now, if you're on a Zoom call, see, I remember, back in the days, you actually had to go into a courtroom and they could put you in contempt. If the judge puts you in contempt and you go into contempt or you go into jail, you're an idiot. This is a modern day culture. They're doing Zoom calls. So they're issuing warrants from Zoom calls. You know what I'm saying? It's not like you're going in, like back in the days, we had to go into court. You know what I'm saying? So like if you go into court and you do this, he was going to instantly put you in contempt. And the reason why is because you're interfering with a public play. So I know all you people in the comment section that believe that when the state issues a law, you have to follow it. Like a state supersedes a man. The man created the state. There wouldn't be any states without the man's creation. So sometimes people really need to understand how natural law works.
Or not?
Please let the record show that I have attempted to understand the jurisdiction of this court and this.
I would just say I accept your contempt on the grounds that I will accept your contempt, and I'll accept your contempt order on the grounds that you prove that the court has subject matter jurisdiction.
Court has refused me that answer, and apparently it is a jurisdiction only understood to bar members and licensed attorneys. You
don't want to make statements. You do not want to make statements in court. Do not make statements. Okay. This is where a lot of people catch themselves and get themselves in trouble. They start making statements. You don't want to make statements. Okay. All your paperwork should speak for itself. Everything should speak for itself. When you're going in court, the way that you speak, don't go in there trying to make claims and statements and all that. No. You have to have facts and proof.
This is a direct violation of the Constitution, and I do not consent. I do not agree. Your Honor, I do not wish to be held in contempt.
It's too late.
I've merely asked a very basic, simple question, and you have refused to answer it. I feel as though the court is trying to constrain me to an unfair plea. And
the court is not constraining you. The judge is. That's why I did the video saying, going over the case, and it shows you that there's a difference between a court order and a judge order. Okay. If he's issuing that order has to come under stamp and seal of the court. Now, if he's issuing an order to put somebody in contempt and there's a jurisdictional challenge, that order is going to be overturned. So hopefully this young brother knows what he's doing to do that.
In the absence of my understanding of the nature and cause of the action against me,
I'm going to order you to report to the Wayne County Jail today.
I do not accept.
I'd be like, Your Honor, you're going to order me to go anywhere where you don't have jurisdiction. That would just be me having a little fun. I wouldn't really say that, but I wouldn't even, because I wouldn't really be here, but if I was, you know what I'm saying? Yeah.
Sir, please don't. I told you don't say. I'm going to add some more days if you keep on talking.
As many days as you want.
You already got 30 days.
I don't understand, sir.
I'm adding more if you keep on talking. Please do not say anything else. It says here, after the court determines whether criminal or civil contempt proceedings are appropriate, the court must determine whether the contempt was direct or indirect. Now, if the contempt was committed during its sitting and in the immediate view and presence of the court, the contempt is direct, and the court may summarily make a finding of contempt and punish the contempt. So I'm determining that this is criminal intent, the contempt. I am determining that it was done during the sitting of the court. On the record now, I've asked the young man, Mr. Jamil Lockhart, or as he has on here, Jamil of the family Lockhart, to continually.
And that all that other family stuff really don't matter. When you in court, a lot of people be saying, "Oh, it's the uppercase name," and they try to distance them. People, just get rid of the damn court case. Stop going in there and playing games. Just get rid of the damn court case so you can live to fight again. Y'all like arguing, man. Y'all have the proclivity of wanting to argue with these people. Get rid of these damn court cases, man. So then they don't issue a warrant for some of you people who can't handle a warrant. You know, for some of you people who know how to handle a warrant, you don't give a damn what they issue. You go stand on your square, and you represent represent who you are.
Not interrupt. The court is trying to set dates so that Mr. Lockhart's motions, if he wants.
So he's interfering. He's interfering with court business. Even though it's not criminal, it may be more civil, but I don't know how their states deal with that type of conduct. But yeah, from what you've seen from the young guy, he kept his cool. There were some things, some nuances that he needed to improve on. But the good thing is when you see where people make mistakes, you can learn from that. Like, I've made mistakes, but I didn't have a template to learn from. I had to go in there and figure the stuff out myself. So you guys have the luxury because there's a lot of video of people going into courts. There's a lot of information on the internet now. So we didn't have all that luxury because there was a lot of misinformation on the internet and a lot of speculation. And that's why I try to clear up a lot of that stuff. It's not to diss anybody or to ruin anybody's philosophies. But yeah, so when you're going in court, make sure if you're going to object to jurisdiction, if you're going to bring up jurisdiction, that you do not let the court proceed past the jurisdiction. Because if you allow the court to proceed past the jurisdiction, they're going to assume as if they have jurisdiction. So you must understand that the prosecutor, when you bring up the jurisdiction, the prosecutor has to respond. If the prosecutor fails to respond, that's who you need to go after, not the judge. Because if the judge didn't sue you, okay, the judge didn't file that case and then serve it on you or send it to you, or they didn't file that case. The prosecutor or the DA did. So your anger shouldn't be at him. He's just sitting on the bench, and that's why he's angry, because the guy doesn't fully know the procedure. And that's why he asked, do you need an attorney or do you need a lawyer? And that's why the guy's like, really, like, you have to understand it. They try to say that you have a right to counsel, right? But counsel does not mean an attorney. So in the Constitution, you have a right to counsel, not an attorney. But I hope this is helpful for a lot of people who understand how to go into court or want to understand how to go into court, and kind of keep your demeanor very calm. Don't be afraid. Don't allow anything to really rattle you, because you're there on a matter. You're on a matter that, as long as you don't say nothing crazy, they can't really put you in contempt. So, in my opinion, would I go to court? Probably not. But starting out, I think, yes, you should go to court. I think if you've never been in a court, or if you've never done any administrative processes or whatever, I think that you should go through court. And that's why I usually recommend people to go through court. That's why I don't try to give them shortcuts, or some of the shortcuts I know, because I want you to see court. Once you see the deception, you'll never be able to close. You'll never be able to look at things again the same. Never. Once you have an understanding of the system, you'll never be able to see things any other way. And with that being said, deuces, and have a good day.